Mark Davies, who's the managing partner of Davies and Associates, who has worked in EB5 for over a decade. He has worked on both regional centre applications and direct applications, so he's very well placed to discuss both sides, both routes to EB5. And we also have from AIG, we have Quendrice. Good morning, Quendrice. Quendrice similarly has worked on both sides, so she understands EB5 regional centre and she understands direct, which gives her, again, a good perspective on how to answer these questions about job creation. Because one of the key areas of difference between direct and regional centre EB5 is the issue of job creation. So let's dive right into it. And really, I mean, Mark, if you want to start us off, can you explain what job creation is in direct EB5 and how it differs subtly from regional centre EB5?
Sure, Duncan. So in its simplest terms, regardless of whether it's direct or regional centre EB5, you have to create 10 new jobs. There is one exception to that, and the exception to that is that there's a way of maintaining some jobs essentially, without getting into the details, for a failing company. When people hear that, they sort of jump on it without sort of thinking it through. There's a reason those companies are failing, and usually when people focus on that aspect, it's a recipe for the disaster. So setting that aside, you have to create 10 new jobs. There's a difference between the way that those jobs can be created in a regional centre and in a direct context. Perhaps it's best to just remind people what we mean by direct. Direct really means any EB5 filing that's not through a regional centre. So it's not sort of special magic language, really. It means any EB5 filing that's not through a regional centre. So with job creation, with the regional centres basically are allowed to provide or document the creation of jobs through the investment of capital, which means that for every dollar of funds that you invest, the US government will imply that you create a certain number of jobs in the economy. So I'll explain both and then I'll give an example. So on the regional centre side, for every dollar spent, you're going to create a certain number of jobs. So your spending of certain amount of capital will imply those jobs. On the direct side, you can't do that. You have to create 10 actual jobs, actual real breathing people, and document that you've created the 10 new jobs. So perhaps if I give you an example, we've opened several factories using direct EB5. We've done salons, different things. But if you take the example of the factory, if you open a factory, and let's say the factory already has 20 workers. Well, if the factory already has 20 workers before you invest, on the direct side, you're going to have to create 10 new jobs. You're going to have to go from 20 workers to 30 workers. On the contrast, if you're a regional centre, then the government think about economic activity. So they're thinking, for example, about the sandwich shop across the street. If you add another 10 workers to that factory, the sandwich shop across the street is probably going to sell more sandwiches at lunchtime. So they may have to hire some more people. Obviously, you can't go around the economy adding up, all of the sandwich shops in the area. You can't add up the new school teachers required, et cetera, et cetera. So the way they do it is by implying it with invested capital. So with that factory, if we buy a couple of new machines for $3 million, $4 million, there may be an economic formula, and this is where economists come in. There may be an economic formula that says that because we spent, name the number, $3 million, $5 million, the US government deems we've created, say, 13 new jobs, right? So there's no actual new workers in the factory, perhaps in that regional center, in the regional center context. But because we've spent the capital, we're deemed to have created sort of the sufficient number of new jobs. Now that's oversimplifying it to the point of being perhaps a little bit inaccurate, but it gives you the idea. On the direct side, we've got to have the actual workers in the factory.
Yeah, absolutely. Thanks, Mark. And that hypothetical was useful. And I think maybe we turn to Quendrice now, because you've on the legal side, we can only really be hypothetical because we're this isn't what we do, but you've done both sides. So can you talk to job creation and the difference between regional centre and EB5 from your experience of both running a regional central project and direct projects?
Yeah, just like Mark said, in the regional center, the jobs are counted based on the number of, or the amount of money that is being invested. So say there is a formula, it's called RIMS2. This is what we've used always. The formula is dictated by USCIS, and there is an economist who makes these calculations, right? And that formula basically says X amount of money that is spent in such and such activities will result in the creation of X amount of jobs, right? So let's say you have a real estate project or a development project, which is very, very usual in a regional center EB5. What you're looking there is how much money is being spent to build that that project or that property, right? And that money, where is it being spent? So hard construction costs create a lot more jobs than, let's say, engineering or management fees and so on and so forth. So there is qualifying expenses that go towards EB5 activities that result in the creation of the job. So it's more of a formula than it is actual job creation. In terms of direct EB5, the jobs are absolute, right? So every year in the US, every employer issues a W-2. So when you're hired, when you're working for a company, you have to fill out documentation. You have to fill out this W-2 information. And then in the end of the year, the HR department of each company will send you a W-2. So now what the jobs in direct EB5 are going to be, they're going to be these W-2 jobs. So at the end of the year, you're going to issue these W-2s, and that's going to show basically how many people work there. So now for each investor, you're going to have 10 W-2s, and each of them have to have 35 hours or more. That constitutes a full-time worker. So that's basically the difference. Regional center, the jobs are calculated based on the economic impact that that project or those expenses are going to make in the area, versus direct EB5, these are absolute jobs. Actual people working there full time.
Sure, and with and you've sort of touched upon it with this W-2 thing. So people are going to wonder, how do you demonstrate and report that? So can you go into a bit more detail about what a W-2 is and actually how you keep those records over the period and under which you need to be compliant with the regulations?
So let's say each company has an HR department, right? So now when you're hired, when someone is hired, you have to fill out paperwork that is reported to IRS, right? IRS is the tax, the tax people here in the US. I lost the word. So basically, you fill out that paperwork that is reported to IRS, and then you're paid. Of course, payroll is done. And in the end of the year, a W-2 is issued. A W-2, then it's reported, you as a business report that W-2 to IRS as well, because it's your payroll expense for a certain individual. And that individual then has to basically, when they do their tax return, because as you're paying them, you're basically paying taxes for them as well, right? We're withholding taxes and you're paying their taxes to IRS as well. So in the end of the year, each employee, each person that works gets a W-2 that shows how much money they've made that year from your company, right? And how much taxes they've paid. And that's a crucial document because they have to have that document to file their taxes for that year. So it's basically payroll, and this W-2 in America is very important. And everyone has to file for taxes in America every year. It doesn't matter if you've made money or if you haven't made money, you have to file for taxes. So then the US government sees how much you've made and basically either makes you pay more taxes or return some of the taxes that you've paid throughout the year. But this is basically, this W-2 is unavoidable. You can't avoid it. And when you're trying to evidence that people have worked here or that you've had these 10 jobs, you have to show these W-2s basically. And you might have two W-2s for the same position. Let's say someone quits mid-year and then you hire someone else to do the same job. That still counts as the same jobs, and you're going to have W-2s for two different people, but they're going to equate to 35 hours a week for the entire year. You know, you have basically then created a job.
Sure, and you raise an interesting point at the end there by saying if someone quits, how long does an investor have to replace that person? Because obviously you don't have someone queued up the next day to do the same job.
Right. So it depends. That's where it depends in the industry. It depends what the business is. It depends what qualifications the people working there have. If people are more specialized, obviously it takes longer to fill those positions up. If people are not so specialized, like say you have a waitress or you know, simple job, basically those are replaceable. You can replace those jobs easier. But I don't think there is, and Mark, correct me if I'm wrong, I don't think there is a time frame, a set time frame by USCIS as to how long you have to fill that position. It has to be a reasonable time. If it's a specialized work, like let's say in our veterinarian clinics, if it's a veterinary doctor who it's harder to hire, there's more, you know, it's longer. It's a longer process to hire a veterinary doctor. Then, you know, it's obviously going to take a longer time. However, the main thing here is to create that job. There is a necessity for that job. So as long as there is a necessity, there is an opening, and you're actively trying to recruit someone to hire someone to fill that position, you should be okay. Am I correct, Mark?
Mark,
sorry, I was muted for a second. Right, so the jobs have to be created within 2 years plus a reasonable period from the adjudication time. So the question of if someone quits, if you can show that it's an active position, then it should qualify. Now, here's to me the sort of big thing with job creation and direct EB-5 is, as with many things in immigration, there's the law and then there's USCIS, right? So the law sometimes may make it sound as though you've got a lot of flexibility in when and how jobs can be created, but you have to overlay USCIS. Now, as you know, in any EB-5, there's two steps. There's the I-526 stage, and there's the I-829 stage. At the I-526 stage, USCIS have to be convinced that the jobs will be created. So you can say, in theory, I've got 2 years from the adjudication time to create those jobs. But reality is, if USCIS don't believe that they're really going to be created, your I-526 won't get approved. So what I'm trying to say is all of these things about, well, if someone quits, that's fine, but you've got to still convince USCIS that that's a real viable position. And that might be more of the challenge here than what the technicalities of the law might be. So, you know, you would really want to make sure the jobs are properly documented, that they're really there. There's a legal technicality in that, you know, with the job creation, you can argue that the jobs are intended to be created within the correct period of time. In other words, perhaps if I start advertising for one, but again, you have to convince USCIS of those jobs. And the easiest and most solid way to do that is to have the jobs. So I'm not saying, and I don't want to be quoted as saying that, you know, under the law, the jobs all have to be solidly there at the I-526, because that's not true. However, the easiest way to convince, especially in a direct context often, the easiest way to convince USCIS that the jobs are going to be created are to have them, you know, there, perhaps even as early as the I-526 stage, which isn't required by the law. When you get to the I-829 stage, USCIS are looking back and saying, were the jobs really created, essentially? So, that's even sort of doubly the case if they want to see, were the jobs created within the applicable window? Now, you can have another reasonable period of time, which they defined as being 1 year, to create jobs. But, again, there's lots of legal arguments that can be made on these jobs, and it can get, you can be quite creative and stretched with those.
It was a crucial thing for us to actually find businesses where job creation would be very straightforward, right? Where we wouldn't have to make arguments, where the jobs would actually be needed. And there isn't many industries out there where you can create 10 jobs with $500,000. So it was very important for us to find businesses and in industries where job creation would not be a problem, because it is very important for the investor in both the I-526 stage and I-829. And I believe, there is many areas that are crucial and important to for a successful EB-5 process, but job creation is
Q probably has a lawyer representing her in that process. And one of the things a non-immigration lawyer is going to do is they're going to check employment compliance. Because as an investor, the worst thing that you could possibly do, or perhaps not quite, but one of the worst things you could do is invest in a company to find out there's a quagmire of employment compliance issues. So just because we're talking about immigration, my experience is most of that stuff that investors would usually do just goes out the window and nobody cares about it, which is ridiculous because you're still an investor in a business. So I think a related point is when we're looking at, are these jobs really going to be there? We need to look at, is the company maintaining proper employment compliances? Because if the jobs are created and there are no compliances, USCIS might not count the jobs anyway, but going beyond that, you don't want to get into the quagmire and the possible liabilities of being a major investor in a United States.
We're going to do X, Y, and Z with your $500,000 and it's going to create 10 jobs. First of all, you want to kind of see our analysis, right? You want to read that analysis. Okay, how is this money going to, what is the industry, right? Where am I investing this money? Then you want to look at the jobs in terms of job descriptions, right? And you can do research on your own to kind of really see, are those jobs really needed for that business? There is also in our business plans, basically, we put analysis there in terms of basically how long that business is going to be open. Let's say Monday to Friday from this time to that time. You calculate how many hours are in there. And just think about it. Like, is this really necessary? Would these jobs be necessary for this business to function? Let's say a restaurant, right? So in a restaurant, you're going to need, people in the kitchen. You're going to need a cook. You're going to need someone who preps the food, depending on what the restaurant is. For example, the restaurants that we have are serving fresh food all the time that is being prepped and cooked right there and then. So you do need people to do all of that, right? Then you need someone who's going to take the orders. You need someone who's going to basically a waitress type of a person who's going to take the food to the table. Then you're going to need a cleaner, let's say, and then you just think, okay, so this restaurant is open, let's say from 9 to 9. That is 12 hours. And that's not basically, though, it's not exactly correct, right? I'm just giving you an example. So that's 12 hours. All right, there is 2 6-hour shifts here that could be done. And then from that, basically, you're like, okay, so you have 2 6-hour shifts, and you can just, kind of just make sense out of it. And also do some research on it as well. You want to do research. You want to research that industry and really understand, are these jobs necessary? And then you want to look on the financial projections, on the projected payroll expenses. Does that number of expenses, the amount of money actually equate to the hours that we're saying people are going to be working at, right? So if there is 300 hours, you want to multiply that by what is the minimum salary, $15 an hour. If that number is much higher than what the financials have projected as payroll expenses, then, that's really not what's going to be. So there is plenty of things that you can do, but I would just really suggest that you ask these questions to the actual project sponsors so that they can walk you through. Right? They can go through the financials, they can go through their analysis, and they can tell you exactly how is it that those jobs are going to be created there, because each business has different needs when it comes to job creation, to the amount of people that they need to work for that business to function.
There's another point on that, Q, is if you ask these questions, you should, and that's great. And certainly if it's an operational business, I think you're insane if you don't go visit the business and actually see these people doing the jobs. They have to be necessary. But often the reason an investor will use a lawyer to do employment compliance is because if a lawyer misses something that a reasonable lawyer should have seen or made an issue, guess what? The lawyer's liable. So you'll find a lot of professional investors. When I began my career, the firm I worked for represented major investment banks, and they were buying or investing in portfolios of things. And, they had large due diligence departments. They had huge internal law departments. They didn't need to hire an external law firm for a lot of the due diligence work we did. They just didn't. The only reason they did was because if something was missed or something went wrong, right, they've got a law firm to perhaps to turn around and sue, someone to take accountability. So if you're an investor, I'm not saying don't ask these questions yourself. Do get comfortable with it. But one advantage of having a lawyer go through employment compliance is if the lawyer should know what the standard things to look for are. And if they miss something, then you may have some protection, if things go wrong through that. So anyway.
Absolutely. But every attorney that represents an investor should actually look at the documents of that project to make sure that they comply with EB-5 requirements. So you need a lawyer who's capable of doing that. I'm so used to Mark because all our projects, of course, are sent as a package. All the documents are sent to his firm and are checked for immigration compliance. So yes, absolutely. You do need an immigration attorney who's going to do some of that work for you, because again, it doesn't matter. It doesn't really matter how long you've been researching EB-5. There is nuances in every project. There is nuances in USCIS guidelines. You can go in and study all they have out there for EB5, and you still won't be able to understand the inner workings of it the way an immigration attorney would. So
it's not just immigration law, because, you know, say I'm sitting in the state of Florida, right?
Okay.
I don't know. I'm an immigration lawyer. I've done a lot of EB5s. I don't know what the Florida state employment law says about some compliances. But I'll tell you one thing: I don't want to invest in a business that's in the state of Florida that isn't in proper compliance. So it's not just about immigration law. As an investor, you want to make sure that it's not only employment, there's other areas. You want to make sure that the entity you're investing into is compliant. Now, I don't think that direct EB5 is inherently riskier than regional center at all. However, in a regional center context, you have a regional center who is the general partner of an entity. As the general partner, they have certain legal obligations to you, and they will pretty much always have sophisticated commercial counsel, lawyers that engage on behalf of the investor group, if you will, just to keep it simple, to do some of these kinds of checks. As soon as you're not in a regional center context, there is no regional center with a legal obligation to do that. So I would argue that regardless of whether it's a regional center or a direct project, you should have someone checking those kinds of compliances. However, when you move into the direct sphere, this is very much more about operators, sort of mid-size, often smaller or mid-size operating businesses. Regional center cases, not always, but can be large real estate type, commercial real estate development type projects. So I'm just saying that, again, to emphasize, direct is not riskier or less risky than regional center. It's all about the projects. However, when you're in a direct environment, I think the need for this kind of due diligence and these kind of checks it's heightened. There's no, I don't want to say that it's not necessary in a regional.
So Mark, what do you suggest an investor do? How can an investor who lives halfway through, on the other side of the world, check these things? Now, are you telling these, right.
I think an investor needs to, when they engage a lawyer, and this may sound self-serving, but it's what I truly believe, so I don't know how else to say it. I think when an investor engages, they should behave like some of the big banks that the firm I work for used to represent. They should ask their immigration lawyer, are you going to be doing, sure, immigration checks on the job creation, but are you going to be checking, for example, in this area, employment compliance is in a non-immigration context? Because if the answer is no, we're not, we're only immigration lawyers, who's going to do it? It's a criminal offense for a financial advisor to do that. Sometimes the answer is, well, you have a financial advisor. Nonsense. If a financial advisor is giving you an opinion that a company is compliant with Florida state Florida state employment law or federal employment law, then go to jail. That's practicing law without a license. Right. So this whole idea that you need an immigration law lawyer and a financial advisor is severely flawed, especially in a direct EB5 context. If you just, don't believe me, go on sort of chat groups with professional American investors and ask them what they look for when looking at these kinds of projects, and you'll find that most of them will tell you employment compliance. Now, employment compliance, I think, is also important in immigration context because you have to document these jobs, right? And they've got to be properly documented in order to sort of get through. So, it's sort of one touches on the other. But my answer to you is I would make sure that whatever lawyer I hire is not only doing immigration work, but they're going to check the basic one. It's like if you Google like due diligence 101 for investors, Noddy's guide to legal due diligence. We're not talking about sophisticated, complex things. The Ladybird book, using a UK example, the Ladybird book of buying a company, or the Idiot's Guide to Buying a Company. It's going to say, number one, hire a lawyer to do basic compliance checks, whether it's in a EB5 context or not. So I think that's my advice, because it's too complicated. I'll go back. As I said, if I was investing in a company in Florida, I wouldn't trust myself to know what Florida state employment law is and whether it's compliant or not. But I know who I would ask.
Right. So here is where I want to jump in now. You know, not every immigration attorney would have someone on board or is qualified to basically do these checks. Now, you can, I know you can, Mark, but not everyone can. And as Mark said, yes, it's true. A financial advisor cannot check that on direct EB-5. A financial advisor could help you in the regional center sense in terms of determining how risky that investment is, that financial risk is, right? Not compliance risk.
Q, you used to be a banker, right? You can
Right.
name the bank if you want to, but in one of America's biggest commercial banks, right?
Correct.
Successful, wealthy
Correct.
banker. So if you were a
Correct.
bank extending a major lending facility to a junior company, would you ever do that if you weren't represented by a lawyer doing basic checks?
Absolutely not. Absolutely not. I would want to retain a lawyer first, and then I would want that lawyer to, you know, do their job and come back to me and then tell me, you know, if that deal works or not.
Part of their job, right, is basic checks. So, you know, I represented banks, not the bank Q used to work for actually, but some large investment banks and other people, and you have a standard checklist. And one of the ones, you know, another one comes to mind, it's not related directly to this, but is when you're investing into one of these entities, no one's checking a certificate of good standing, right? So when you invest, say, in a company, let's say there's a little, I don't know, hot dog stand in Florida where I am. If it's set up as a company and I'm going to become a shareholder, one of the things on any lawyer's checklist is to get to ask, usually you don't go get it yourself, usually ask for it, is a certificate of good standing to make sure that the company that you're going to become a shareholder with is in good standing with, in this example, the state of Florida. My observation in talking to direct project operators is nobody asks for that. Again, in a regional center context, I still think that as an investor, you should ask for that. But reality is, regional centers council is almost certainly going to ask for those things. In a direct context, there is no regional center council. It doesn't exist. So no one's asking for it. And we had an example, I was just saying on a blog yesterday, we had an example. I found an investor who had invested in a company, and guess what? The company wasn't in good standing. So he had invested in a company that, as far as the state involved was concerned, was sort of almost due to be struck off. You know, and bluntly, you know, his immigration law is probably going to be liable for that, because that's such a basic, it's like the Ladybird book of investing in a company. If your immigration lawyer isn't checking something like that, then they probably have an ethical obligation to be advising you that you need to hire competent corporate counsel to do so. But anyway, sorry, Q, I'll let you talk about it.
No, you go ahead. But what I was gonna say is, because so the goal is here to really make life easier for that investor. And the one thing I can tell you is that when you put a deal together, when you're putting a project together, we actually have immigration counsel, we have securities counsel, we have attorneys who work on putting these deals together to make sure that we are compliant. And when an investor, you as an individual, you hire an attorney, that attorney is looking out for your best interest, right? Because she is retained by you, right? So they're working for you. They're not working for the project, right? They're not working for me. They are liable to you, not to me. So yes, going back to what you said, Mark, it is important that you hire an attorney that actually is going to check certain things, right? And they have the capability of doing that.
What I think we could do, before I steal Duncan's show, what I think we could do is, there are standard checklists for this type of due diligence. And whilst I think you would be foolish not to have someone who knows what they're doing looking at it, I'm pretty sure if anyone wants it, our firm could share such a standard sort of due diligence checklist, but it's pretty long, and it'll have things like, the incorporation certificate for the business entity, certificate of good standing, Some states, not all states, some states have a requirement that a business file sort of a continuation of business statement every year or two, or some states don't have that, others do. It just varies. But I'm sure we could share our sort of, due diligence checklist on these things. But, I would just caution you that it's one thing to send a due diligence checklist. It's another to know whether the materials that you've sent back are raising any concerns.
And also, that checklist must be pretty general because not everything applies to every business, right? You're going to have business-specific questions that 100%. You're going to have once you see a project, right?
So in your example, I would want to make sure that these vets have licenses, right?
Right.
It would be a disaster.
Absolutely.
It would be a disaster to invest in a veterinary clinic to find out the vets involved. Let's say it was in Florida, the vets involved don't have Florida state veterinary licenses.
Right.
That would be the end of the business, pretty much. Right?
Absolutely. Absolutely. You can't go any further.
Let's get back to jobs specifically, because we're going to be breaking down a lot of these areas of different areas of compliance and what to ask for in different webinars. And there's still many threads here to follow on the jobs side of things. But we had a really good question earlier. You guys just referred to I-526 and I-829 without going into too much detail. Can you explain what these two stages are and maybe put that into context about job creation? So when jobs need to be created and what happens at both stages. Just unpack that a bit more for some people who don't necessarily understand.
Would you like to do?
I can do it. So at the I-526 stage, USCIS is receiving a package of documents where basically they're looking at different things to make sure that, it's a qualifying business where you're investing the money. They want to make sure that you've invested into a qualifying business that is going to create 10 jobs. So at that stage, you are sending USCIS, together with us, an analysis. You are basically, there is a business plan that explains how these jobs are going to be created, when they're going to be created. There's a timeline as well, and why these jobs are necessary, right? So at this stage, basically USCIS is looking at the business plan, it's looking at job creation, it's looking at the financial analysis, it's looking at is the project in a TEA? That's very important. But also they're looking at your source of funds, right? Your individual application to approve you as an individual or not. At the I-829 stage, you're basically already in the US. You've already been living here for almost 2 years under a conditional green card. And at that stage, USCIS is saying, all right, so you've invested, you've made a qualifying investment into a qualified business. Now I want to know that $500,000 that you have invested has actually created at least 10 jobs for you. So at this stage, we're proving to USCIS that your money has created the jobs. And I think that's the only thing that they're looking for at this stage. This is only job creation. They're not looking at other things, versus in I-526 stage, they're looking at a lot of other things as well. So it is important who prepares, your application. In terms of the business, we provide all the documentation, and then there is that individual side of it. Your source of funds, your individual, history and biography and all of that stuff. So,
just to add a little bit here, it's really important to understand that this USCIS practice and rules and regulations can be a little bit different. So technically, under the law, you've got 6 months, you've got 2 years from 6 months after the adjudication, and you have to show that it's more likely than not that the jobs will be created.
Right.
And this is what I was saying earlier. That sounds like quite a flexible standard, but believe me, when USCIS look at direct projects, they're applying that in a very stringent manner. Now, you can argue that you can go to court, you can do this, you can do that, but you don't want that. You want a smooth, simple approval. So people get excited by the idea of, well, the jobs don't actually have to be created. And, just to go back to what I said before, the more certainty you can bring to this job creation, really the better. don't rely on this more likely than not. That might be what the HCFR, that might be what the regulation says, but you want to get a swift and smooth adjudication. And USCS want to be very convinced that if they haven't already been created, that these jobs will be created at that I-526 stage. Sorry, Q.
No, absolutely. Absolutely. You really have to make a case for it. And whoever is adjudicating your application, they actually do have a database that they can go back to, right? Where they see, is this industry really going to create these many jobs? Are these many jobs really necessary, in this type of a business? So yes, absolutely. You want to have a good case for it. You really want to have something where like it's simple and it's understandable and it's easy to grasp, it's easy to understand, it's not complicated. Definitely. And no one wants to be arguing with USCIS. You want something that is very straightforward.
And so that begs two further questions. Once you have you apply with your I-829, it's approved, you get the conditions removed from your green card. In direct EB-5, you may still be in possession of the business, of your stake in the business. At that stage, as an investor, do all the checks on the jobs. I could fire everybody and still keep my green card at that stage.
Well, once you file for your I-829 to remove the conditions from your green card, pretty much you've reached your sustainable period, and your EB-5 process, as per the investment side of it, is done. Am I correct, Mark? That is usually when we devise an exit strategy for investors who want to exit the business. That's when they can exit. Actually, they don't have to exit.
I've just seen this many times. People begin to set up businesses, Q, whereby they can get rid of the jobs quickly. And as soon as you start to do that, you start to get into areas where USCIS challenge the permanency of the jobs, right? So, I just you can answer questions about these rules, and you can answer them in a way that makes this sound, really very flexible. Because, for example, you at the I-829 stage, the standard is they must be created within within a reasonable period of time. So what does a reasonable period of time mean? A year? Well, you can extend beyond that in extreme circumstances. As soon as you tell an investor that, they're like, oh, I can prove extreme circumstances. Well, the answer is probably no, you can't. Or it's very difficult to convince.
Mark, there is nuances here, Mark. Okay, so if you're going to open a business and you're going to hire 10 people, and then at the I-829 stage, you're just going to fire them, that means that those jobs were not necessary for that business. And USCIS is going to crack that before you get to that point.
So, perhaps an example of that, I like examples, Q, is there's this case, there's several trucking company cases in this area. And what happens is, just looking at the names on this, a lot of people are Indian, a lot of Punjabis come to America and they set up a trucking business. And, they need, say, just making this up now, but they say need 3 trucks. Each truck has 2 drivers, that's 6 jobs. Then maybe they have, a dispatcher, a salesman, et cetera, et cetera. You get to 10 jobs. Well, then what happens is actually they end up with not having enough business. And it's always the case that with these cases that there's a cousin or an uncle or a friend who knows the trucking business and everything's going to succeed and it's low risk. And reality is quite often they just don't have enough loads to justify running 3 or 4 trucks. So then USCIS look at it, and USCIS have, what's the right word? Have models, templates for different industries. So they look at the revenues coming in, they look at things and they say, no, you don't need it. Jobs disallowed, case denied. So, when you look at jobs, when you're looking at a project, just think about what Q said is, are these jobs really needed and how are they demonstrated? An advantage of something like veterinary is, if you have, regardless of the revenues that the business is generating, if you have a vet who's working in an office, a vet's going to need probably, I don't know the way the veterinary business works, but perhaps they need a veterinary assistant, right? and they probably almost certainly need a receptionist. So it's perhaps a little bit less of a revenue-centric model. But some of these businesses are very, very revenue-centric in terms of sort of the jobs implied.
Right. So, see, the thing is, like, if you look at our business plans for both our deals, the veterinary and the restaurant deals, you're going to see that we project the jobs increasing, right, by year, because we are projecting the revenue to increase by year. So those jobs that you see that are increasing, the second year, the third year, and so on and so forth, those jobs are based on our projections of revenue. Now, the jobs that you see on the first year, right now, those are the jobs that are actually based on the necessity of operating that business as soon as you open the doors. So it doesn't depend on revenue, right? You need to have those jobs. Those jobs need to be there for that restaurant to have its doors open, or for that veterinary clinic to open its doors. And then you have the jobs that are projected to be added by, increasing revenue. So there is a difference in these things, right? You can sit there and project and be like, all right, I'm going to make millions and millions of dollars in this business. No one can tell you you're wrong, right? Because you just might. But when it comes to job creation, you want to make sure that the jobs you're actually presenting, especially at the I-5 to 6 stage, are actual jobs that are necessary for that business to operate, to open its doors. So this is very important. And then if it's performing well, you go and you add more. That's a different type of a thing here.
So what we're sort of talking about here, some investors are looking to invest in a prepackaged product of the likes that AIG offer. Other investors want to invest in their own business. So we kind of have to sort of explain the difference to some of the people on the webinar at the moment, and also explain, maybe this one for you, Mark, in terms of producing that business plan. Obviously, if you're going to invest with someone like Q's company, the business plan is created for you and you're doing more of an interrogation of their business plan. Mm-hmm. Whereas if you're planning to set up by yourself and start your own business plan. So Mark, could you just speak briefly to the sort of the challenges associated with doing a direct project yourself and what needs to be done? You're on mute.
You're on mute, Mark.
Sorry. So what I was going to say is there are a number of several very well-known cases that address business plans and what's required in the business plan. So it's quite common for a client to say, oh, I've already got a business plan. Well, 9 times out of 10, that business plan they've already got won't work for EB5 because there are specific requirements from an immigration perspective that need to be in the business plan. The system that different firms do this differently, and I'm not saying the way we do it is right or wrong, but the way our firm does it is we send clients a questionnaire, and then we have a business plan team who works with one of our EB5 lawyers to develop a draft business plan based on the questionnaire. And then that business plan tends to go backwards and forwards between the investor, because it's the investor's business plan at the end of the day. It's his business. So it has to be right. It has to be what he's actually going to do. So then it usually goes backwards and forwards a little bit to develop something that, we're comfortable meets the requirements of the immigration law, but also accurately reflects the investor's business. When you write business plans, you also have to be cognizant of the future. If you're doing direct EB5, that's one thing. Often clients are doing an E2 visa or another kind of visa, and long run, they might want to do EB5. So when we write an E2 business plan, the detail required for an E2 business plan is not as detailed as EB5. But often we write an EB5 business plan. Why? Because if we come back in 2-3 years and we want to file an EB5, we don't want there to be inconsistencies in the E2 business plan or something in the E2 business plan that's going to cause a problem for the investor to qualify the funds he's already invested. So business plans, actually very critical. One of the most important things with direct EB5. It is very technical, and there are several cases. Again, not difficult. I want to get into the details now because we'll be on the call another 2 hours. But if you want, contact our firm and we'll even direct you to the law cases. You can read a couple of these seminal cases that talk about business plans And probably that'll do nothing more than make you realize that you probably do want an EB5 lawyer to be writing this business plan for you, because it is very technical. And even if we give you the cases, you still have to check that there aren't subsequent cases that amend some of these requirements and update some of these requirements. So, this is something where I think you'd be very well, again, it sounds self-serving, but you'd be very well advised to have an experienced, not just EB5 lawyer, but a lawyer who's got experience with direct EB5 cases. Because in a regional center context, the lawyer probably isn't writing the business plan. That's usually prepared by the regional center and the regional center's counsel. So investor counsel in a regional center context usually doesn't write those business, or usually isn't involved in the preparation of those business plans. In a direct context, there is no regional center counsel. So especially if you're doing your own project, some of these pre-packed plans like Q's veterinary project, she probably has a business plan for it to share. But if you're doing your own business, there isn't one. So you need to work with, I would say, a qualified and experienced direct EB5 lawyer. And ask also for an EB5 lawyer, ask him to refer you to, or her, to refer you to clients in the same industry and from the same company. Because, if you have experience with trucking companies, for just using the example, from experience, there are some unique issues that come up in an EB5 context in the trucking industry. So actually, if I'm going to start a trucking company, if it was me, I would want not only a lawyer that's experienced with direct EB5, but I'd want a lawyer who's experienced with the trucking industry. And you know what? I would ask to speak to some of his trucking industry clients who have successfully been through the process.
Well, I know we're supposed to be talking about jobs, so I have some more specific things to just really get into jobs, because I think it will answer some people's key questions, because we haven't really talked about types of jobs, and Q, you might be able to help here. So we talk about, like, what about two part-time workers? Can you have a one part-time receptionist and one part-time engineer in the same business, and would that count towards jobs? Can you talk to what a job actually looks like? And also, can you talk about, if you have multiple sites, if you have different veterinary clinics in different cities, and can two different sites add up to one job requirement? How does this all fit together?
So basically what we do is we want to diversify the investor's risk, both financial and EB5 risk, which is the job creation, right? So the way we have structured these deals is that an investor basically has direct ownership in 4 different locations. Now, these 4 different locations, all the employees that are built, we're going to run each group, right? So there is 6 investors, 4 locations. We're going to run each one of these as a business, as one business. So what's going to happen here is that it's going to give us, it gives us the flexibility to have more jobs, of course, but also to basically, let's say you have you need one full-time receptionist and one part-time receptionist, right? So that part-time receptionist is not going to count as a job, but your business doesn't need it to be a full-time. So what happens is we'll hire one receptionist, right, full-time, and then the one part-time. Basically what we will do is we'll hire that one full-time as well, and have that person's time split between 2 different locations. So that actually then is a full-time job, because there's this one business that has 4 locations. So all the employees are considered to be within this one umbrella. So you can do that. Now, when you were talking about the part-time, it also works if you have 2 part-time people doing the same job, right? So if you have 2 part-time receptionists, that equals to 1 receptionist. But if you have 1 part-time receptionist and 1 part-time technician, that's not a full-time job. That is just 2 part-time jobs. So for part-time jobs to qualify, you have to have 2 people working the same job. Let's say different shifts maybe, but 2 people would have to be working the same job. And again, because we have 4 locations, let's say under one umbrella, we're able to kind of eliminate this part-time job completely, because we will just have one person work in two different locations. Like, let's say Monday to Friday, they're working in location A, Saturday, Sunday, location B, depending on the necessity. So you can do that when you have an investor basically spread in four different locations. And this is also good, diversifying basically your risk as well in the financial sense of it, right? So you're spread in four different locations. So if one of them doesn't do very well, you still have the three others that could cover for it, both financially and in terms of job creation.
Just one thing that's worth mentioning is, because it causes some confusion, is the law defines a job really basically as where the compensation is coming from directly from the new commercial enterprise. Mm-hmm. That causes some confusion with independent contractors. So I've seen cases where investors have come to us wanting to start a business, and they've talked about independent contractors, and they may have spoken to a lawyer who's read this law that says that the compensation needs to come directly from the commercial enterprise, and have been told that independent contractors therefore qualify. This is another area where USCIS policy arguably is not consistent with the law. USCIS are not going to allow independent contractor jobs, right, Q?
No, they're not going to allow.
You know, the law and USCIS practice are sometimes at variance, and this is another example.
Absolutely. No, as per EB-5, you need full-time employees, not independent contractors. Absolutely.
It's not really a jobs question, but we had a few questions on the same issue that you guys can answer. It's about making the $500,000 investment. It's like, at what stage does it need to be invested? At what stage does it need to? Do you have to do it all at once? Do you have to? When can you sort of get it back? All these sorts of questions. Can you talk to the investment, just so people have a bit better?
Well, if we're talking about, let's say, a sponsored deal, right? Let's say our veterinary clinics. If we're talking about that, then you can pay in installments. We can make a payment plan with you where and together with the immigration attorney too, because what you want to do is you want to file your petition even before you have invested the $500,000. So you have to work closely with your immigration attorney to show that you are in the process of investing. And sometimes in the process of investing basically requires that you have the funds already and that you can prove that you are going to make this investment. We will issue a securities note. It's a process, but we can do it. So you can pay in installments. We would have to have this conversation basically in private to understand your financial situation, to understand how you could do it, and then make sure that it works for the business, right? But also you have to speak to your immigration attorney in terms of source of funds and in terms of proving to USCIS that you will make that investment so that you can file that petition. Other than that, then you're going to have to wait until all of your money is invested to file your I-526 petition, because USCIS requires that you either have invested $500,000 into a qualifying business or are in the process of investing and can tell them where you're going to get the rest of the money with proof, with documentation, and when is that money going to be invested. So that part is basically you investing. In terms of getting the money out, right, being paid out, if you're opening your own business, I can't answer that for you, right, because it depends on your business. Now, on our deals, after you file for your I-829 or to remove the conditions from your green card, you will have the option to be bought out of the investment. So basically, we will ask you if you would like to sell your shares back to us. You will make money during this year. You will make, there is revenue basically will be shared with you based on your percentage, based on your ownership in the business. And then at the end, we'll ask you if you want to be bought out of it. If you like the business, if you like the income that it's giving you, you can continue staying invested, we would welcome that. If not, we can buy you out, basically.
So, this is a interesting area. And, just to sort of go back to the basic, I think there are two things that are relevant. First is Q is obviously quite right to say that the money is invested or in the process of investing. Generally, investors and bluntly some project operators jump on this language of in the process of investing, and they say, well, I'm going to give 100,000 and I don't know where the rest is going to come from, but I'm in the process of doing it. We know that won't qualify. You can take the risk out of that a little bit by looking at something else. Is you have to invest. Well, what you haven't talked about is what do you have to invest? So if you're talking about a project, right, that is looking for capital, they're going to ask you for cash, but that's not the law. The law says that you can invest all kinds of different things. So in the context of people doing their own business, you can invest inventory. So say, for example, you have a textiles business in India and you want to open a warehouse in America. We had a case like this. You can send stock, right? The inventory that you send to America to sell, that could count as investment for EB-5 purposes. Now, where this is relevant, I think, to what Q's talking about is the definition of capital, right? You are invested if you've contributed the required capital. Capital includes a secured promissory note. So sometimes what you see is this: some operators are willing to say, Q says you can give me, I don't know, $250,000 in cash right now, because now is the current Indian financial year and I can send 250,000 easily. And then maybe I'm going to send another 250,000 on May the 2nd or something. One way to perhaps make that lower risk is to meet the definition of capital today for the entire $500,000. How will I do that? Well, I've given half of it in cash, right? 250,000. But then a secured promissory note, you don't even get into the business of in the process of investing, because a secured promissory note is capital. So if I give Q a secured promissory note for 250,000 and I give another 250,000 in cash, that has met the definition of capital for EB5 purposes. So we're dealing with something that's actually fully invested. We don't even have to deal with this language about in the process of investing. What does it mean to have a secured promissory note? It means that I write a note, write an IOU, basically a legal IOU to Q, and then it has to be secured by capital. The problem is, again, looking at sort of the names on this, there's a lot of Indian names. This then becomes a question of Indian law, because if you're talking about India, that capital has to be available to Q to come and take. My understanding, I'm not an Indian lawyer, but we have a couple of Indian lawyers we work with, but my understanding of Indian law is that if you attempt to secure a foreign debt obligation with real estate in India, that doesn't work. That's not permitted under Indian law. An Indian lawyer, please correct me if that's wrong. But if that's true, assuming that's true, then it's very difficult to have a secured promissory note using property in India to secure it, because it's going to be void. So you have to find some kind of property somewhere that can secure this note. If you are resident in the United Kingdom, that's easy, because I can secure the note to Q with my house in the United Kingdom or a property in the United Kingdom, and Q by law can come get it. So what I'm trying to say, point I'm making is this: there's degrees of risk on this. And, there's been a couple of times in EB5 when a couple of regional centers, which I will not name, to me entered into very risky policies of saying, you can give us half now, and as long as you give the rest within 6-7 months, you don't have to prove where it came from. Nobody cares. And I remember arguing with the general counsel of a regional center about it, because I think that's risky. I think you need to do at least what Q said, which is to identify very securely where the money's going to come from. One of the things that we do sometimes is, if it's a question of remittances, you can put things into an escrow account, and perhaps you send 250,000 to Q, and you lock up the other 250,000 somewhere else in an escrow account with a deal structured. So there's only one thing that can happen to the money, which is it goes to Q. In an Indian context, that's challenged because you can't structure an escrow account in that way. But one of the Indian banks, ICICI, structured something, or was looking at structuring something whereby you'd use essentially FDs to do the same thing. But point is that, number one is there's risk, right? Some of the risk is this idea of sort of in the process of investing, and there's ways of being in the process of investing. If you're in the process of investing, you want to document exactly what the money is and where it's going to come from. But why not take out all the risk and find a way to contribute other things that meet the definition of capital? Then you don't even get into that problematic language of in the process of investing. Sorry, Q, was that clear or was that convoluted?
No, absolutely. So basically, just to summarize here, what we're saying is you can invest part of the money and the rest could be secured by a note, but it has to be a property that I can come and get it, right? And the other way is to be in the process of investing, but in this way, when you're in the process of investing, you have to identify the funds. Like you have to show that the funds are there and you're, let's say, not being able to transfer them today versus 2 months later for a certain reason. So you have to identify where the funds are coming, where the funds are, right? You have to make sure that you have that proof. So if you actually have the money in the account and you can send it, then there is no reason to just, there is particular situations where these things apply and they are doable and we can do them. But again, it really varies from person to person, from individual to individual. It really depends on your situation, where you're from, what your circumstances are.
Duncan, I think we should do a webinar about opening your own business in a direct context. And one of the topics there is what we talked about is non-cash stuff that you can contribute. So inventory is an example. I can remember a diamond, Gujarati diamond guy. Obviously their stock could be worth very significant amount of money that they transfer. So point is, read the law. The law says capital, and capital includes lots and lots of things, not just cash.
Right, and we just have one extra question, Q. It's slightly off topic, but you've got multiple locations at your site, and obviously, to qualify for the lower minimum investment threshold of 500,000, it has to be in a targeted employment area.
Right.
How do you make sure that if you've got multiple sites that they're all in TAs?
You get a TA letter. You get an economist to give you, to do an analysis. You send that to the state, and the state comes back and tells you this is a TA. So you make sure it's in a TA. Every location needs to be in a TA. If you have a business and it has 200 locations, all 200 have to be in the TA. If your EB5 investment is in that business that owns 200 locations. So you have to make all of the locations have to be TAs.
And so I guess you hit on an important point. People should be asking for those letters from a project provider.
Of course.
They need to. And so Mark, so the letter, it's just a one page that you can show for all your locations, other providers possibly as well. Mark, if you are going into doing a direct project yourself as an investor, how do you make sure that where you're choosing to invest is in a targeted employment area?
Right. Well, this got a little bit complicated, Duncan, because as people may know, there was a rule change, or the government tried to change the rules back in 2019, and they actually changed the rules around how this was to be done. And then a court came down and struck down those rule changes, which include, mainly it's quoted for sort of the investment amount, but this also changed the way in which TAs are terminated. So it's, decided. So that this shift, right now it's shifted back into the hands of the state. So you have to get a state TEA letter documenting that the project is in a TEA. Now, let's also remember, TEA stands for Target Economic Area. You can also invest in a rural area being an area of low density population. So there's two things. There's the rural area and there's the TEA. Now, frankly, there are some things that won't qualify as a TEA, but for two reasons. TEAs can there's a reason that they try to make the law more conservative and stricter. One is, with a little bit of creativity and perhaps the help of an economist, you can demonstrate that a lot of strange places, including places in Midtown Manhattan, are TEAs. Hence, that Hudson Yards project is in a TEA, right? That's smack in the middle of Midtown Manhattan.
And all the veterinary clinics are in Manhattan as well, and they're all TEA.
Right. So there's sort of the TEA aspect from that perspective. And then, the second thing is, remember, it's a letter from the state. So think if you're the state. If you're a state, you want to encourage job creation in your state, right? So my experience is states tend to be quite lenient with this. But why? Because they want the business to start. They want this business to start up in the state. So I'm not saying that everything qualifies as a TEA. That's a ridiculous and silly thing to say. But a lot of strange places do. And remember, the other thing is investors will often say, is the town of X in a TEA? Well, part of the town of X might be and not another. In New York, this goes like block by block. In a direct context where you're doing your own business, we always like it if the client's in what I call a natural TEA. What does a natural TEA mean? A natural TEA basically is a TEA that's a TEA because of the land on which the project stands, as opposed to having to go through this sort of TEA gerrymandering. One of the ways that they gerrymander these TEAs is with a chain of tracts of land. So imagine that your building is like on a tract of land and it doesn't qualify as a TEA. One of the ways that has been done to make this work is you take the adjacent tract of land and the adjacent tract of land like that and the next adjacent tract of land, right? So you could end up with your project in, say, Midtown Manhattan, and you could end up with a chain of these tracts of land that stretch out into Brooklyn and Queens, which are very, very different places. You average them up and you get a TEA. So
now let me ask you a question, Mark, really quick. So this is the reason why USCIS changed the regulations back in 2019 and introduced a different way of qualifying a TEA because they didn't want to leave it to the state. But like, let's say I have a letter from the state and it tells me that where I'm building this project is a TEA. Can that be challenged?
Well, I think that USCIS would be, that the mechanism for determining it is like currently through the states. The state certifies a TEA. Now, obviously, if the USCIS think there's gross error, and potentially they could label it fraud, couldn't they? They could say, well, the only reason that the state wants to do this is for certain purposes. Ultimately, they could challenge. I've never heard of a case like that ever. So I don't want to come down and say it's always 110% certain, because I could foresee certain circumstances where they might challenge it. But as a practical matter, I've never heard of a state TEA certification being challenged by USCIS. But I don't want to say it's impossible that could ever happen, because it could foresee circumstances. But I think if you've got a state TEA certification letter, that's pretty safe. That's going to be on the document checklist for most law firms. There are projects where clients have invested in where they don't have the TEA letter first. So the TEA letter doesn't make the project in a TEA, right? It's just, you better be very, very certain that it's a TEA and that you're going to get the letter. You want to document that it was a TEA at the time of investment. So it's very important that that's done in a timely manner, and you want to create that evidence with that TEA certification letter. But the point is that the letter doesn't make it a TEA, it just declares it to be a TEA. And I can think of several examples where, it was a hands down clear cut TEA, and the TEA letter came later and there was no problem. But unless you're really, really certain, I would say that's a very risky strategy. You certainly want documentation from an economist, but back to you, Keith.
No, I have nothing more to add to it. It just, it also depends on the business, right? Because, for example, let's say for the first 4 veterinary clinics, we have the TEA letters and all of that. What we could do is like you go and you find other locations now, and you go through the due diligence and you go through the analysis of that location. Is it going to do well? Is it going to do this? Is it going to do that? So what we do is we kind of pick, let's say 10 locations that we like to run analysis in it. But before we run the analysis, we want to make sure that they're all TEA, right? So we go and we check that they are all of them TA, and then we pick 4 that make the most sense, both financially and, you know, for EB5 purposes as well, you know. So we do that. We go in, we find multiple locations, and we get the TA first before we go into more work and kind of like a location, and then it turns out not to be a TA. You don't want to do that. But yeah, absolutely. That's how we select them.
Great, thanks, Q. So really, we've covered a lot of ground today, but at its heart, job creation is one of the most important aspects of EB5. In direct EB5, you have to be able to demonstrate at least 10 full-time jobs, and how you build that up is sort of up to you, but it needs to be built up in a way that is, you know, with these tax forms, these W-2, they need to be real jobs, and you need to be able to, and you have to be able to demonstrate that there's a requirement for these jobs is what I'm hearing. You can't just have sort of ghost jobs to meet your 10 job requirement. It might be worthwhile having extra jobs as a buffer, just to sort of build in some extra security for your compliance issues. And ultimately, there are 2 ways to do this. You can either go through a project provider such as Q, and there are others on the market as well, and you need to be asking these questions of them. And I think, Q, you pointed out that you really need to sort of do your own calculations and basic due diligence on this. Do the maths, just try and build up, work out what these jobs are, work out how much the average salary for these jobs
or have someone from that project walk you through it, you know, go through it with you.
Exactly. Go visit the project if it's already in existence, and really you should be working with an attorney on all of this to get some, not only for just getting some impartial advice, but also in terms of liability, as Mark says, that you sort of share your risk and liability.
And you know, another thing is this, Duncan, is, you know, again, you know, I mentioned this before, I'm not saying regional center projects are better. I've been accused of saying that. I don't believe that. However, in a regional center context, right, you've got, you know, generally a regional center checking on the documentation as you go along. In a direct context, you can't assume that. There's no obligation on anyone to do that. So one of the things after you invest is, I would be asking the company for proof of job creation as I go forwards, right? You want to make sure that that documentation is being kept as you go along. So if it was my case, it was one of my clients, I would be asking for sort of updates on the job side documentation as the project progresses. You know, again, in a regional center context, you can ask the regional center for it. In a direct context, there is no regional center, so you have to ask the business itself.
Right. There is no regional center standing behind it in terms of the legalities of it, right? But for example, we are a regional center. Now we're doing direct EB5. It's just that we don't have that same liability as we would have as a licensed regional center offering a regional center project. We are the same people. We're doing the same due diligence. It's just in terms of liability, right, Mark? It's different, right? Because it's a direct.
Well, there's no one on the hook. What Q's saying is
correct.
There's no one on the hook to do it, and that's
right.
You know,
you can count on the experience of the people doing it because they've done regional center projects before, but there is no one on the hook. That's true.
Great, thanks, guys. Do you have anything else to add on this topic, or anything wider that you want people to know? Excellent. Well, thank you for your time. Thanks for everyone for joining. This is part of a series. We're looking at different aspects of direct EB5. Next one, we haven't got a date yet, but we're going to look at investor participation because, as Q knows, as a direct investor, if you go into some of these projects, there is a requirement to be actively involved.
Yeah, there is. There absolutely is. You do have to be involved in a direct business. Absolutely.
And so what that looks like and how that's shaped and what's incumbent upon you as an investor will be the topics we discuss next time.
Okay. Thank you so much, everyone. Bye-bye.
If you have any questions, just call or email us and we can follow up privately.
Mark, you're muted. If you want to say bye.
Oh, sorry. Yeah. Thank you very much, everybody.
All right.
Look forward to talking to you again. And if anyone wants any of the materials that we referred to, you know, please do reach out and we'd be very happy to provide them. And I'm sure Q would too. So
absolutely. Absolutely. Thank you so much.
Thank you.
Thank you for having me. Bye-bye.